next matter to come before us is, are the same parties, but in different matters. Santomauro versus Sun Property Management. And Mr. Reed, you have 15 minutes.
Thank you, Your Honor. Your Honor, I would save 2 minutes if I could for rebuttal.
Sure.
Thank you very much, Your Honor. The relief I'm asking for is for this court to determine that the trial court, and that would be Judge Kimbler, abused his discretion in denying our request for attorney fees. Now, the attorney fees we requested were from defendant Santomauro for his willful breach of what was a clear settlement agreement made on December 6, 2017 and placed on the record. So now we are a year and a half out from an agreement that was made perhaps reluctantly, but nevertheless voluntarily in the courtroom in front of a judge and on the record, read into the record by Mr. Souls, who was lead counsel for Mr. Santomauro's company, of which he is the managing partner of Sons Ltd, or LLC, excuse me. Now, I know that we moved for sanctions under 2351 time limit. The court denied our motion, and the court denied it without granting a hearing on the basis that there was apparently no reasonable basis for sanctions as stated in the motion. I think that's the standard. And I know it's difficult for the court to say that any judge has abused his discretion. That's a difficult standard. I don't like making it about a judge, and I don't like asking an appellate court to sit in judgment of a court and say, you've abused your discretion. Nevertheless, I realize also that this is not just a question of a mistake of judgment or a mistake of law. In fact, it goes to arbitrariness or caprice on the part of the trial court. And I think that's exactly what happened here. We are all brought up with the idea that everybody should pay their own attorney fees, and the American law provides, and that is generally the rule. But in some cases, and 2351 is an exception to the general American rule, that you can get attorney fees under certain circumstances. And where the conduct of a party has been vexatious, and where it has been dilatory and designed to delay relief to a party, sanctions should be granted, and sanctions should be granted under 2351. Now, in this case, we've heard a lot of arguments here today about why this contract, why this agreement, this contract should not be enforced. But the fact of the matter is, on December 22nd or so, whenever they filed their motion asking this case to be vacated, the court reasons were that Mr. Santomauro was incapacitated, and he was cognitively unaware of what was going on about him. And of course, the argument is still made that these lawyers who read Mr. Santomauro's agreement into the record, having read that, they had no authority to do it, and that Mr. Santomauro never made any objection to it. I think that's inconsistent with the law. When he stands there and listens to this agreement and does nothing except make an occasional reference to parts of the agreement, which he did do, by the way. But at any rate, at that time, the court indicated if, in fact, you are making the contention that you were cognitively impaired, neurologically impaired, emotionally unable to enter this agreement, you have to bring a doctor in to do it. Well, they did bring a doctor in to do it. They brought a doctor in who had no opinion whatsoever as to this man's cognitive state, his neurological state, or his emotional state during the 3 days that this case was negotiated in December of the year 2017, a year and a half ago. So did they comply with what the court said? In a way, yes. But in a way, it was just a willful disregard in contempt of the agreement and of the court. They have walked away from an agreement that is clear on its face. They snubbed the court by bringing in a doctor who knew nothing about his cognitive state and say they shouldn't be determined to have been vexatious litigators.
Counsel, did the doctor testify as to the effects of the medication that he was on?
Not on him. They testified generally what could be the effects of medication, but nothing about how it affected him. And
so basically side effects.
Yeah, right now. And I think that the doctor's testimony is somewhat interesting in terms of what he had to say beyond what I have are summarized for you, but there's no question about the fact that he had no clue that day as to whether he was impaired in any fashion by either the medications or by this bronchitis. So the fact of the matter is, I think that the conduct in this case by the defendant, snubbing his nose at an agreement that was made by his lawyers in court, snubbing his nose, thumbing his nose, and snubbing the court by bringing in a doctor who knew nothing about his neurological state, cognitive state at that time. And then raising for the first time in that hearing, apart from the motion, the fact that, oh, I don't have authority. I don't have authority to transfer 17 properties out of 73 because that would basically wipe out the business. I mean, there was no evidence of that, none. So I would respectfully submit to the court that in spite of the burden that is imposed, that you must find that the court used its discretion in denying our opportunity for a hearing, that you should grant the relief that we want. Let us have a hearing. The court doesn't have to grant us fees, but we are certainly entitled to a hearing consistent with the case law in Martell versus Martell, out of, again, a rival appellate jurisdiction in the 5th District, and also a case, even though it didn't apply 23-2351, the Prociano case out of the Eastern District of Louisiana, that dealt with the inherent powers of federal court to grant sanctions where there has been vexatious litigation, also dealing with the settlement agreement. Both of those cases do. I will take my 2 minutes if the court.
Thank you.
Thank you.
Good afternoon now. Your Honors, Attorney Connie Hightower on behalf of the defendant Sums Property Management LLC. I would like to advise the court that Mr. Santomauro, although repeatedly referred to as the defendant in this action, is not the defendant in this action. The defendant in the underlying trial court case is Sums Property Management LLC, and I think that that is a large distinction that should be made, as there was no individual case that was filed against Mr. Santomauro. He is the manager of Sums, but not the defendant in this case. Your Honor, there's a few things that I would like to point out as to appellant's brief. First, the issue of the frivolous conduct in which, or why we are here, or what the filing that was made. There's 2 plaintiffs in this action, Lisa Madden and Marsha Santomauro. Marsha Santomauro had previously filed in January of 2018, shortly after the motions to return to active docket had been filed by Sums' previous attorney, and there were some responses. In her response, she had an entire section that was devoted to why she believed that this was a frivolous action and why they believed that sanctions and attorney's fees should be granted. That was in January 2018. There was more litigation that was done. Of course, we had the hearing on March 13th and then the decision on March 28th and the final appealable order on April 18th. At that April 18th final appealable order, the judge indicated that all motions for attorney's fees are denied. That would have denied Marsha Santomauro's motion that is similar in almost every way, part and parcel, to what has been presented by Lisa Madden to the court. That is very important because in the judge's finding, or one of the reasons under 2323.51 that the judge does not have to hold a hearing is if they're familiar enough with the case, understand enough about the facts to the case, they can deny the motion without holding a hearing. If they grant the motion, they're required to hold a hearing. In this case, because this judge had to consider an almost identical argument that was presented to the court by Marsha Santomauro, the other plaintiff, he had already reviewed whether or not there was frivolous conduct involved and had already denied that. Again, the court issued another order in May, and I'm sorry, I didn't have the date right here, but I believe it was somewhere around May 22nd, 2018, after the motion had been filed by Lisa Madden, which indicated that all pending motions are dismissed. So the court, again, intended to dismiss that motion. Because Lisa Madden had filed to the Court of Appeals to do a remand to the trial address that motion, the case was remanded. During that remand, then the court again addressed that motion. So first the dismissal was made and then the remand. And so the judge in the case then addressed, again, this would be the third time he's looking at whether or not the motions to return the case to active docket and invalidate the settlement agreement were frivolous. And the decision that was issued as a result of that indicates that it was not. In fact, he says that he cannot find that there actually is a legitimate issue, and the court denied that motion unilaterally as it can without holding a hearing. Specifically, under RC 2323.51, it says that if they're going to grant the hearing, then they set the date, they give notice, and they conduct the hearing. As we outlined in our brief, although the plain language says conduct a hearing before awarding, the converse is not true, and that has been held consistently in this court. We cite in right annexation of 18.23 acres of land to Fairlawn, DeCarlo versus Estate of Maxwell, Caligaris versus Quality Mold, and Goose City versus Felton. In all of those cases, it was found that the trial court has enough knowledge, and if they have enough knowledge, they can deny that request. Appellate's counsel had addressed Mr. Santomauro snubbing the court, something about how the physician was brought and demonstrated nothing. This was also flushed out in the court's decision, that just because the physician did not give a failure on his physical condition and whether it rendered him incompetent does not mean that it's determinative of frivolous conduct. What we also should point out is for some reason, the appellant or the plaintiff in this case does not acknowledge the supplemental filing on March 12th, which was filed with the court, which outlined additional reasons why the settlement agreement from December 6, 2017 should be invalidated. That was a supplement to the previously filed requests, which were done about December 22nd, and I believe somewhere around beginning of January, there was a response about January 10th. So that supplemental motion also included other terms. We cannot, Your Honors, just fixate on a term that the appellant wishes to fixate on as to the physician. There were many other reasons of which the trial court has said are legitimately on appeal and corresponding appellate case number for why that there cannot be a determination as to frivolous conduct merely because the plaintiffs have an opinion about the validity of a physician's testimony. That physician did talk about Mr. Santomauro's diagnosis. He did talk about the types of ways that either that diagnosis and or the medication could affect someone's mental state. And so there was information that was provided. He had also sought to provide information as to the operating agreement as well as the revised code and his abilities to be able to do what he, whether he could acquiesce to anything as the manager.
As I understand, the diagnosis was bronchitis, and he was placed on antibiotics and an inhaler.
And I believe pneumonia. I believe it was bronchitis and pneumonia.
Okay, but the medications were inhalers and antibiotics.
Your Honor, I don't know what to call those antibiotics because I believe that he addressed those by names of the medications. But yeah, he was put on medications as a result of that, and the doctor did testify to those. So, Your Honors, we don't believe that the trial court abused its discretion in refusing to hold a hearing when it had already flushed out these issues. Where the trial court is familiar with the case and there is no clear evidence of frivolous conduct on the record, the trial court has the ability to deny a motion for sanctions or based on frivolous conduct without holding a hearing. We believe that's a well flushed out question of law. We believe that the 9th District has flushed it out completely, and we believe that the plaintiffs were not entitled to a hearing in this regard. For that reason, we would ask for you to affirm the decision of the trial court. Thank you.
Thank you. Mr. Reed, the way we work it is if you only ask for 2 minutes. If you say 5 minutes, we'll allow you to do it. It's up to you.
Thank you, Your Honor. Let me address, first of all, this issue of standing, and that is why I'm up here and not Mr. Meeker. Mr. Meeker's client, Marsha Santomauro, did move for fees following the March hearing, March 13th hearing, when evidence was put on about the doctor, etc. All the reasons why this settlement agreement should have been vacated. We did not, on behalf of Ms. Madden, make a motion at that time. Now, if I were to come up here and say, I'm moving for reversal on the basis that the court denied attorney fees, you'd ask me, well, what's your standing? You didn't file a motion. That would be the right question for you, and my honest answer to you, if I didn't file a motion, I wouldn't have standing. We filed timely after the court entered its final entry on April 18 for sanctions under 23-2351. The court then ruled upon our motion. And I'm up here on our motion, not on Mr. Meeker's motion, not on Marsha Santomauro's motion, but on our motion, which was timely filed, and for which I did have standing, and which I still have standing to raise. And I raise it for the reasons that I've already discussed.
But I think her point is the judge was, because of that, was more familiar than ordinarily if you just filed them at the same time, for
Right.
instance.
And Your Honor, I don't dispute the fact that the standard in this district and in many districts is, as I pointed out in my brief, it seems like the statute reads that a hearing should be granted under any circumstances. That is not the way it's been applied by this court or by other courts. And I've mentioned that in my brief. But I still think it was an abuse of discretion not to have had a hearing based upon the reasons I cited in my motion. So whether, if you're saying, do I think the court abused its discretion when it denied Ms. Santomauro's motion filed by Mr. Meeker? Yes, he did. He abused his discretion then, and he abused it the second time. Mr. Meeker has appealed. I have appealed. And I believe there was a sanction, sanctionable conduct by these people. And in fact, under 23-2351, we should have been, at least on the basis of my motion, granted a hearing. And I think we should have won the hearing. But I would ask the court to look at the language in Martel. In Martel, that was another case where people get the creative idea that if you bring a doctor into a court to testify to somebody's cognitive impairment, that's good enough. And in that case, the court didn't sanction the party. The court sanctioned the lawyer because of the fact that when you're talking about cognitive impairment, you should do more than just ask a couple questions. You should explore that area thoroughly. And what I'm saying in this case is that I'm not asking for sanctions from the lawyer. I'm asking for sanctions from the defendant's sons because of the fact that what they did in this case was just, they thumbed their nose at the court, and the court let them get away with it, and this court shouldn't. And also the case that I mentioned before about Cosciona, that's a case, again, it's out of the Eastern District of Louisiana. It's a relatively recent case, 2017, I believe. And in that case, the court, again, it ruled on sanctions, the inherent power of a court, as this court has, to sanction people, not under 23-2351. But, and in that case, the court said, this settlement was so clear, and in that case, the argument was made, these lawyers didn't have authority to speak for me. They had authority to negotiate, but they had no authority to close the deal. And the court said, that is sanctionable misconduct. That is tantamount to what has happened here. Two cases, both bearing on issues that are raised, in this case, on this appeal, on behalf of this company, and both cases, the courts held, that's sanctionable misconduct. And I would ask the court to take a look at the motion we filed and to grant us the relief requested. I appreciate your time. Thanks so much.
Thank you to all parties for their arguments here today. And the court will take the matter into advisement. We'll issue a written opinion, which will be sent to both sides and also released on their website. Thank you. And have